Hi, everyone. My name is Allison Grosz. I'm an attorney and a partner with Hemrick PLLC here in New York City. Today, I'm going to continue with my What Is series, and today I want to talk about what is the 90-day rule. If you recall, in the last several weeks, I've talked about what is an immigrant visa, what is a non-immigrant visa, and what is a dual intent visa. Well, the 90-day rule has to do with these. So let's talk about what is the 90-day rule. The 90-day rule applies to non-immigrant or temporary visa holders who enter the United States, and whether or not they are allowed to change their status from a non-immigrant temporary visa status to a permanent or legal permanent resident status. The 90-day rule is what USCIS applies to temporary non-immigrant visa holders who then change their status to a permanent resident status or make any major life changes that would lead to their ability to change their status to a legal permanent resident status. So what does that mean? This means that when a temporary non-immigrant visa holder enters the United States and that person applies for a green card or makes any major life changes that would allow them to apply for a green card within 90 days of their entry in the United States with a non-immigrant visa, USCIS presumes that that person committed fraud. There is the presumption of fraud if a person makes any of these changes within 90 days of their entry to the United States under non-immigrant intent. Now, this is not to say that a person who enters with a non-immigrant visa and has non-immigrant intent is not allowed to change their minds at a later time. It doesn't mean that somebody with a non-immigrant visa, such as a B visa, an F visa, an M visa, a TN visa, or several other kinds of non-immigrant visas. It doesn't mean that you're not allowed to change your circumstances, change your status eventually, and apply for legal permanent resident status for some reason after you've entered the United States. All it means is that you cannot be doing those things within 90 days of your entry to the United States under one of those non-immigrant visa classifications. Now, what does it mean to do something that would violate the 90-day rule? Well, like I said, you can either come into the United States with a non-immigrant visa and then apply immediately for a green card based on some other legal ability that you had prior to entering the United States with that non-immigrant visa that would have allowed you to, rather than enter with a non-immigrant visa, enter the United States with immigrant visa status. It also means that if you get married, for instance, to a US citizen and you got married within the 90 days of your entry to the United States, USCIS could apply the 90-day presumption of fraud rule to you to presume that you intended at the time that you came with a non-immigrant visa to really get married to a US citizen so that you could apply for a green card or legal permanent residency status thereafter. The 90-day rule doesn't only apply to the actual filing of the application for legal permanent resident status. It also applies to the getting married. The 90-day rule can also apply to other things, such as when a student visa begins unlawful employment within 90 days of their entry to the United States. Some asylee seekers begin employment within 90 days of their entry to the United States, or under other circumstances. If a person violates the 90-day rule, this 90-day rule can be applied at any point in the future. So for instance, if a person enters with visitor visa status, and then they get married to a US citizen, and they do not apply for any legal status, however, they got married to a US citizen within 90 days, even if they apply for legal permanent resident status several years later for whatever reasons, that 90-day rule may apply to them. This can also be if a person enters the United States with visitor visa status, they apply for asylum, and they're denied asylum and leave the country. Oftentimes, if a person leaves the country after being denied asylum and then tries to re-enter the United States several years later with legal immigrant status, if that asylum seeker had begun working in the United States within 90 days of their entry at the time that they applied for asylum, I have oftentimes seen the Department of State apply the 90-day rule and block a person from being able to come back to the United States with legal immigrant status that they are perfectly eligible to receive because of application of the 90-day rule. So as you can see, this 90-day rule is very wide-spanning, and it can also be very long-spanning in your life. For this reason, it's very important to not violate the 90-day rule. And if you are afraid that you will, or you think that you might, or you want more clarification on the 90-day rule, it's very important to consult with a qualified immigration attorney. Us here at Hemrick O'Malley, PLLC, talk to people all the time about what is the 90-day rule, how to avoid violation of the 90-day rule if they have questions about that, or to answer any other immigration questions. We're happy to hear from you. You can reach us online at hemrick.law, or you can reach us by phone at 833-848-7838. Until next time, I look forward to talking to everyone soon.